Okay, so you want to make the other side an offer they can't refuse. Let's talk about Part 36 offers and Calderbank letters. Okay, so settlement. You basically are in a dispute. Either you want to sue somebody or you're being threatened to be sued by somebody and you want to settle this. Um, so you write to them, either as the claimant saying, look, we will accept this to go away. Or as the defendant, you go, how about this for you to go away? But there's always, the issue of costs in court proceedings. So say you want to just be very certain about how much you're paying. So we will settle this. This is the amount I'll offer you in full and final settlement of your claim, including your costs. Okay, or vice versa. We will accept this, and we'll accept this towards our costs. That's generally called a Calderbank letter. Now, the good thing about Calderbanks is you can put in anything because it doesn't have to be money. In exchange for you doing this, we'll transfer that bit of land to you, or something like that. Or in exchange for you not suing me for this, I'll make sure that the next job, the next contract that comes along, you can have it. Okay. And the great thing about settlements like that is, if you're in the middle of litigation, you can actually put those on the back of the court order, so they become enforceable. It's what we call a Tomlin order. But again, that's a topic for another day. But let's say, what happens if you make an offer either as claimant defendant and the other side don't accept it, you go to trial. Well, then the losing side or the winning side, they can refer to their previous offers. And it's what, have they beat their offer? Let's say, for instance, a defendant says, I will give you £5,000. And you go to court, it's turned down, they go to court, and at the trial, they're awarded less than £5,000 or £5,000. You can then say, well, hang on a second. This trial was totally pointless because they could have had this way, way back then. So they should pay all the costs of this trial. Or the other way around. We are the claimant. We said we would take £5,000 to go, we'd accept that. You've now awarded us, £5,000 or more. So, we obviously get our costs. I mean, the winner usually gets their costs anyway, so that's perhaps less important. But it's a great thing for the losing side to be able to show and say, we offered them this. Even if you're close, it's like, well, look, we offered them nearly this, so that should be reflected in costs. But then costs will be on what we call the standard basis, and it is trite law that you never recover all your full costs. You're lucky to get 70%. So what if you want to put some real pressure on the other side? Well, then we have a formal procedure called Part 36 offers, because it's in Part 36 of the Civil Procedure Rules. Now, you've got to be very, very careful with Part 36 offers. There's lots of case law of people making tiny, tiny mistakes with it and it having hideous consequences. There is a standard Part 36 form you can use, which I would advise you do use. I mean, you theoretically can write your own letter and say, this is a Part 36 offer. But I would say it's just not worth the risk. So the deal is, either side can make a Part 36 offer, either before a claim is issued or once proceedings are underway. You can actually make them, in the middle of trials. You can actually make them at any point up until the judge actually returns a judgment. What you do is you say, if you're the claimant, you say, we will accept this amount of money. And if you're the defendant, you say, I will offer you this amount of money. Now, if the claimant accepts that, the defendant is agreeing to pay the costs, subject, and it's subject to assessment if not agreed. So it's a bit of a free for all. I mean, there is always the possibility of agreeing the cost, but if you actually alter that to say, and we agree the cost, then it's no longer a Calderbank letter because of these very strict requirements. But what happens if then there's a refusal and it goes to trial? Well, then, if the losing side, it's whether you beat the Calderbank offer. So say, for instance, the defendant, to go back to the other example, has offered the 5,000 and, you've only won 5,000, or the claimant said, I'll accept 5,000, they won more than 5,000. In that case, yes, you get the costs, but you get them what we call an indemnity basis, which is the one where you end up paying a lot more. And that is specifically a punishment for not accepting, the offer. So that's why Part 36 offers, there is a lot of pressure on people to sort of consider whether to accept or reject them, because it's a heck of a risk if you get it wrong. Part 36 offers, they have to be open for at least 28 days. But one thing that catches a lot of people out is they remain open until expressly withdrawn. So you might write and say, this offer remains open for 28 days. And then, at the door of the trial, the other side say, yeah, we'll accept that. You say, well, no, that was months ago. You said 28 days. Yeah, but you never told us it had been withdrawn. So if you do want to withdraw an offer after the 28 days, you have to expressly say that. But yeah, so those are the two main types of offers. Like I say, Part 36 is the formal one. We tend to use the word Calderbank for anything that's not a Part 36 offer, even though technically, arguably, Calderbank was a very specific situation in a Scottish divorce case. But yeah, it's just one of those words we use. But I hope you found that useful. And like I say, if you are about to get embroiled in litigation, this is something to really think about. So, take some expert advice on this. Oh, and speaking of experts, thank you, Lord Loverduck. If you like this video, please consider clicking the like button. And if you want more content like this, please consider subscribing. And also, please keep hitting those comments because, it's really interesting to read them. It's lovely to engage with you. And, I do get a lot of useful ideas from them. And, being incredibly lazy, that's great for sort of thinking up about things.